Well, good afternoon. Thank you for your patience waiting through things today. I'd like to call the meeting on Senate Jobs and Economy Committee to order. Welcome to those of us joining here and in Las Vegas and online. I am Senator Marilyn Dondero Loop, and I will be chairing the meeting today. Will the committee secretary please call the roll?
Senator Canizero, Senator Daly, Senator Neal, Senator Wynn, Senator Rogich, Senator Steinbeck, Senator Titus, Chair Dondero Loop.
And I am here, and please mark Senator Canizaro present as she arrives. Thank you very much. And before we move on, the standard housekeeping, please remember to silence your phones and laptops. And please state and spell your name for the record. And if you have a card, please hand it to the committee secretary. Lastly, there will be public comment at the end of today's meeting. Today we'll be hearing Senate Bill 8. That is what we have right now. We may recess, but right now we will be hearing Senate Bill 8, and it revises provisions relating to employment. So I'll open the hearing on Senate Bill 8, and I'll invite Ms. Valentine and Mr. Muradkin to the table. And please begin when you're ready.
Good afternoon, Madam Chair, members of the committee. Paul Muradkin, M-O-R-A-D-K-H, Executive Vice President for Government Affairs for the Vegas Chamber. Thank you, Madam Chair, for your time today, and the committee members. As many of you know, the most important element for a business to succeed in Nevada is a stable regulatory and legal environment. The idea that you see today in Senate Bill 8, as a result of a recent court hearing from Nevada Supreme Court that was issued on October 30th. Our premise of this bill is to address the continued stability that our businesses seek, that they've operated in good faith for decades, and the premise that the assumptions were made that are presented today to you in Senate Bill 8. The Chamber believes that this bill, if not addressed, will have a negative impact not just on small and large businesses, but all aspects of Nevada's business economy and employers who have operated in good faith for decades. As you can imagine, we were surprised by the court's ruling, and we appreciate the body for considering this. There will be an amendment we believe that'll be coming shortly, that we believe will be coming forward to you, that we believe is applicable to the bill, and the Chamber of Commerce's intention to support that amendment moving forward as part of the bill. Madam Chair, it is now my pleasure to introduce Paul Tremmer, who's with a partner at Jackson Lewis from the Las Vegas office, to walk you through the bill and answer any technical questions you may have, Madam Chair.
Please go ahead.
Hi, my name is Paul Trimmer, Trimmer. I'm a partner at Jackson Lewis, and I practice in Las Vegas. I'm here today representing the Nevada Resort Association. In Amazon Services versus Malloy, 141 Nevada Advance Opinion 50, and it was issued on October 30th, 2025, the Nevada Supreme Court addressed a question about the legislature's intent in Chapter 608 that had been certified for it by the U.S. District Court for the District of Nevada. Specifically, the question was, does Nevada law incorporate the exceptions to compensable work that are laid out in the Portal to Portal Act? The court answered the question in the negative. This bill is intended to address the impact of that court's decision and the impact it has on both employers and NRS Chapter 608 statutory scheme. It reflects the legislature's longstanding intent to incorporate the Fair Labor Standards Act and the Portal to Portal Act's exceptions to compensable work, as well as clarify the manner in which Chapter 608 calculates overtime compensation rates. The legislature, employers, and employees in this state have always understood Chapter 608 to incorporate those principles established by the FLSA and the Portal to Portal Act. The Supreme Court recognized as much when it observed on page 5 of its decision that Nevada wage and hour laws mirror those found in the Fair Labor Standards Act. In fact, employers in Nevada have relied on the applicability and interpretive principles found in those analogous federal statutes. There are some aspects of Nevada law which are significantly different, such as NRS 608-160's clear language about tips, or 608-018's daily overtime requirements. But as it pertains to compensable time, there has never been, until this decision, daylight between Chapter 608 and the FLSA and the Portal to Portal Act. The legislature, employers, and employees have relied on those federal statutes to fill in the gaps. The bill before you today reaffirms the long-standing intention of this legislature to incorporate the FLSA and Portal to Portal Act's provisions, which exclude certain activities from compensable time. So I want to first start with Section 1, which amends NRS 608016. And it refers to several different provisions in the federal regulations. It refers first to Sections 2 and 4 of the Portal to Portal Act, and those deal with travel time and other issues that are excluded from compensation by that act. And then it refers to different regulatory provisions under the FLSA. Section 201, 785.14 to 17, 785.26, 785.27, 785.32, and 785.33 to 785.41. And I'll walk through what those mean. 785.27 through 32 concerns attendance at lectures, meetings, training programs, and other similar activities if those are outside normal working hours, they're voluntary, and they're not related to an integral or indispensable activity of the job, and no other work is being performed. Section 785.33 through 41 adopts the FLSA's definitions of compensable and non-compensable travel time. 785.17 adopts the FLSA's definitions of compensable versus non-compensable on-call time. 785.14 through 16 adopts the FLSA's definition of compensable versus non-compensable waiting time. And then the final addition to NRS 608016 concerns doffing or donning, which is the term of art used in those statutes for changing clothes. That's all it is, it's changing clothes. And there's very well-established rules about when employers and employees are entitled, when employees are entitled to be compensated for changing their clothes. If those clothes are clothes that they can wear home and clean themselves, if the employer, as many resorts do, provide clean clothes as free of charge, and the time spent changing into those clothes is not compensable. And the same goes for certain types of protective equipment that they can take home. If, for example, someone owns their own hard hat and they can take it home and bring it back to work, that's not, putting on the hard hat itself is not compensable time. Section 2 of the amendment incorporates the FLSA's methodology for calculating the regular rate, which is used to compensate employees when they work overtime. It would be irrational for Nevada to calculate the overtime rate in a way that differs from the FLSA. Employers in Nevada have relied upon the use of the FLSA's regular rate calculation for decades. And because Malloy relied on the absence of language to find a departure, this nuts and bolts bedrock rule in the FLSA is included in the amendment to eliminate any ambiguity. And it basically, NRS 608018, like federal law, provides that employees will be compensated at 1.5 times their compensation rate when they're performing overtime. But these provisions that we've asked to incorporate in the amendment determine or set forth the calculation that's used, like what types of bonuses will be included when calculating the regular rate, what types of other provisions or carve-outs will be used when they're determining how much the compensation might be. So for example, if I make $10 an hour, which is lower than the minimum wage, but $10 an hour, and I work overtime, then I'm going to be paid $15 an hour for every hour that I work. And in certain circumstances, if, for example, I work in a job that gives me premium pay, where I get a $2 an hour spiff, the regular rate calculation ensures that that spiff is included in what my overtime compensation would be. And it also ensures that certain employer-sponsored benefit plans that are carved out in the regular rate calculation are not included in the calculation under Nevada law. This is just to ensure that what everyone has been doing for decades is what we continue to do, and deal with the interpretive methodology that the court in Malloy employed. The last change that's in the amendment is in Section 3, which deals with how this is going to be interpreted and applied to cases that are pending now and how it'll be implemented. So we included this to ensure that it's clear that the legislature's intent has always been to incorporate the FLSA and the Portal to Portal Act, except in those limited situations where there's express language to the contrary. It's intended to clarify the state of the law for all causes of action that are pending, both in terms of the legislature's general intent and in terms of the provisions that are specifically referenced in the bill. I realize there are a lot of details in this bill, and that's why I've been asked to be here today, and I'm happy to answer any questions that might be asked. So thank you very much.
Madam Chair, my name is Virginia Valentine, Valentine, and I represent the Nevada Resort Association. And on behalf of our 72 resort hotel members, I'm here in strong support of SB 8. For decades, Nevada employers have relied on a clear and consistent, well-settled understanding of PAP practices based on federal and state case law regarding pre- and post-shift activities. This framework has guided employer policies, employee expectations, and operational practices across our industry for years. We're simply asking today to maintain the status quo. If this issue is not addressed legislatively, employers will be forced to make significant immediate changes to how workplaces function. Those changes would directly and negatively impact employees and eliminate benefits that have been part of the resort industry's culture for decades. For example, employees who currently choose to arrive early to eat a complimentary meal in the employee dining room before their shift, or who stay after work to eat or socialize, would no longer be able to do so. Keep in mind that employees depend on public transit or rides from family and coworkers. They routinely arrive early or wait after their shift ends. The everyday activities they've grown accustomed to would be limited or eliminated. To give you some examples, the change would negatively affect access to on-site HR, uniform services, employee services, and complimentary health and wellness assistant, or other free benefits on property, and these services are widely used by our employees. Without legislative clarity, employers will be forced into restrictive, impractical, and costly operational changes, eliminate flexibility, and degrade the supportive workplace culture that Nevada resorts are known for. We cannot underscore the severity of the consequences that will occur should decades of past practice and long-established customs that our industry has followed in good faith be undermined. For these reasons, we strongly urge you to pass this legislation to preserve the long-standing framework that has supported our workforce and industry for many years by incorporating these exemptions under FSLA and the PPA into Nevada law. And I want to thank you all for taking this matter up at this special session.
Thank you very much. And does that complete your testimony? Thank you very much.
Yes.
All right. With that, committee, do we have any questions? Senator Daley.
Thank you, Madam Chair, and if you'll indulge, you can cut me off whenever you want, but I have several questions. Comment, first of all, when Mr. Marakian, I believe, started speaking, he said that, one of the things that all businesses in Nevada need is a reliable regulatory process so you know how to act. And I don't necessarily disagree with that, but you also heavily rely on having happy employees, without which you cannot perform and operate your processes and businesses and various things. And we'll get to some of the questions on how we get to happy employees. Just a comment, but you have to have the employees, and I think they're just about equally important. I know Ms. Valentine was talking about what's going to happen and all these horrible things if we don't pass this portal to portal. So question would be, all of the things that you said about, well, they can come in and they can use the free HR, they can come in and drop their kids at daycare if you have it, and it's good that you have all of this, that's great. They can come there early before their shift at their convenience, but they don't actually clock in for that, right? Is that all voluntary work? I mean, they're not required to be there at your behest, so they are not going to get fired if they don't come and do that stuff, and they're not going to get fired if they don't leave and if they stay after to have their meal. That's all voluntary time that they're doing on their own volition.
Madam Chair,
Please go ahead and go
Through you.
straight to Senator Daley.
thank you. Senator Daley, that's an excellent question and an observation that the time the employees spend doing those things it's voluntary time. The problem with this decision and how it would impact employers' ability to continue to offer those services starts with what's called the continuous workday. So once an employee performs a compensable act, every minute they spend at the employer's property is compensable. And getting into the back of the house at a resort at many places can require badging in, going through a security checkpoint, showing a badge to show that you're entitled to access. The issue in Malloy, and that was particularly true during COVID, and it was also is particularly true after October 1. Under Malloy, any time an employee goes through one of those checkpoints, they've performed compensable work. At that point, every minute they spend on property, even if it's not doing anything else related to work, remains compensable. And the other point that I would make is that under the status quo, employers keep no records of what employees are doing in the back of the house prior to the time that they clock in. That would become a problem under Malloy because both Nevada law and federal law for the very long time, in fact, under the case in where the U.S. Congress felt compelled to enact the Portal to Portal Act, it enacted a presumption that in the absence of records, an employer will be held responsible and will be required to compensate employees when they can't demonstrate that those employees were not performing compensable work. And so your point's a good one, but it doesn't take into account the way that employees would be performing some compensable work when they come on property.
Just for clarification, you said once they clock in, that's it, they're on time, and you got to pay. So you pay them through lunch?
Resorts, the typical shift is 8 hours of scheduled time with 7 hours of productive time and 1 hour of paid lunch and break period, which exceeds the requirements of Nevada law and federal law. But they are paid, Nevada resorts pay their employees through their lunch and break time.
So when they clock in,
Mm-hmm.
they went through their first checkpoint, and that was a compensable act, and that's when their time starts.
Well, no, let me be more specific. So under
Mr. Trimmer, if you'll just say your name, please,
Oh, I'm
for the
sorry.
record. That's okay.
I haven't done this before.
That's,
I apologize.
it's okay.
So Paul Trimmer for the Nevada Resort Association. The issue is that under Malloy, if they go through a checkpoint to get into the back of the house, they've performed a compensable act. But that is not when the employee clocks in. In the status quo, if you went down to a hotel tomorrow and went into the back of the house, you'd walk in, you'd show your badge, and then if you were there 30 minutes before your shift or an hour before your shift, you could go in and take advantage of the clean clothes that the company has provided. You could sit in the employee dining room, drink free coffee, eat snacks and whatever, and then 5 minutes before your shift begins, you would go to the clock that's closest to where your workstation is, wait, the clock in when your shift begins, and go to work. That's how it works right now. But under Malloy, if you go through a security access checkpoint, or you show your badge, and it's not clear where, or you go through a health screening checkpoint, as they did under COVID, that's a compensable act. That starts the clock, even though the employee has not yet clocked in for work. And for everything that takes place after going through that security checkpoint, they must be compensated in the absence of the Portal to Portal Act.
And thank you. And just to be clear, maybe for everybody else, maybe for the record, when you're addressing Malloy, that's the name of the case that's brought us here today. However the name was, I don't know if it's this guy's name or whatever, but so that's the name of the case. I understand.
Yeah.
So we're here to address and fix the court's interpretation that's at A because we haven't adopted these specific things. They don't exist. I understand the liability part of that. But in our adjustment, and that's what we're here to figure out, is what adjustment are we, how much of the Portal to Portal Act are we going to adopt? When do we say a person's compensatable time starts? We can adjust that in the state law as long as it works with the federal and is not less removing part of what the federal requirement is. We can be above that, and we can have different rules and various things. So let me understand, and what we're trying to say is that you're saying because the case is we have to go to the portal, and we have to say all of this time is excluded. So let's take it away from your people, because it's not just one rule, it's not just for the Resort Association, it's not just for people that are under collective bargaining agreements, which have probably protections and various things. It's for every worker in the state of Nevada. So let's take the guy that was at Amazon. And under his circumstance, and whatever it was, in this case it was a COVID test, right? He had preliminary, and I believe the words used by the federal government is ancillary work. That's not the work he was hired to do. He was hired to pick packages and move them and stamp them and get them ready for shipping. That was his actual job. So there's preliminary time that he was required to be there
Yes.
under the portal to portal, if adopted the way you guys say, is non-compensatory. He won't get paid for that.
Well, that,
Or any other work. Let me finish.
I'm sorry.
Or any
Apologize.
other worker. Then he's going to clock in and go to his shift. That first half hour of the day was required to be there. He's going to be fired if he doesn't, unpaid. Then this same guy at Amazon, wherever it was, has his post-preliminary work that he has to do because they have a theft control deal, and it's 30 minutes to get out, get x-rayed like at the airport. I don't know what they do, but nevertheless, they have that. And he's required to do that, but it's post-preliminary. It's ancillary. It's not picking packages and sending them off for shipping. So he is now paid, or not paid for that last half hour of his day. So he actually there, required by the employer, 30 minutes before, 30 minutes after in this example, 8 hours paid, but he's required to be there for 9, only paid for 8. Do you think that's a fair and equitable way for us to treat workers in Nevada when they were under the direction and control of the employer? So we could make an adjustment here on this bill, and we could change and adopt the Portal to Portal Act with a small change that says, if you're under the direction and control, you're required to be there or you're going to get fired, that you have to be paid. It would address your issue. They're not required to be there till they do that first act, and we could, first act of clocking in. Is that a fair statement on how what we're trying to ask to do if we just adopt the portal to portal for that guy that has Amazon?
Well,
That's how it would work for him, right? 9 hours of required time to be there, only 8 hours of pay.
Paul Trimmer for the Nevada Resort Association. That's a good question.
Is it true or not? I mean, that's the way the Portal to Portal Act works right now. If I read it and understand it, preliminary ancillary work, not part of his regular work, is not paid, even though he's required to be there under direction and control of the employer. Same with the post-preliminary work. That's correct, right?
Well,
No, is it or isn't it?
it is, but the
Okay, it is.
There's a
All I
Portal
needed
to
to hear.
Portal Act.
Thank you.
It doesn't.
I'll stop for now, Madam Chair. I might have some follow-ups.
Thank you very much. And I'm going to very quickly turn this over to Senator Wynn. I have got to run upstairs for about 5 minutes to present part of a bill, and so I'm going to let Senator Wynn take over and keep with the questions going. Thank you very much, and I shall return shortly. Don't anybody leave.
Thank you, everyone. Does anyone else have any questions? Go ahead, Senator Steinbeck.
Thank you. And I know that Senator Daley wanted a yes or no answer, but I'd like to hear more explanation as to the question that he just asked, just a little bit more of the nuances that I believe he wanted to explain.
Thank you. Paul Trimmer for the Nevada Resort Association. So I guess the first thing to say is that, and this is true for a lot of situations, bad facts make bad law. And Malloy involves health screenings that took a significant amount of time, partly because employers were brand new at implementing them and operating them. It is true that the U.S. Supreme Court considered the exact same situation in Integrity Staffing Solutions and concluded that that time is not compensable under federal law under the Portal to Portal Act. Malloy considers the exact same situation under state law, dealing with employees that have to go through those health screenings. And as that applies to the Nevada Resort Association and the industry, The problem is not just that the time spent going through the screening is compensable. It's that once they go through the screening, if it's deemed compensable time, the clock starts. So we cannot allow employees to spend time in the back of the house going to the EDR, utilizing services. A lot of resorts have employee gyms. They have health services. Employees would not be able to utilize any of those things because they would be on the clock. In the absence of this amendment, in the absence of the Portal to Portal Act, those employees would be on the clock from the second they walk into the building. They would have to be in order to protect ourselves from litigation over whether or not time is compensable. So that's sort of what Ms. Valentine was referring to. There'd be a lot of, when we're talking about happy employees, I like to say that every resort is kind of like a small town. Many of the resorts in Las Vegas have 6, 7, 10,000 employees. And every single resort is very different in nature, and they have lots of different traditions. But many of those traditions evolve in the back of the house when employees are able to spend time off the clock, socializing, even spending time working with their unions. All of that would have to stop if the second they walk into the building, they are on the clock.
Thank you. Thank you.
Do we have any other questions? I think Senator Daly has some follow-up. Go ahead.
Would like to follow up on that. And I just want to understand, maybe I don't. And I understand your tradition. So they can come in, they maybe use their badge to go through to get into the parking lot security. I mean, in theory, you could say it started there, right? But I disagree. And we can write the law to say that's not when their time starts, right? Portal to portal would apply to that. When they're under your direction and control, they start. But you said they wouldn't be able to go to the gym. They wouldn't be able to go to once they start their shift, then they can go in and out. You said they're already paid for lunch. They don't. So they can go to the gym during their work shift. They can, that's the way I understand you were saying it. He was talking about your shift. You said, once they clock in or once they come in. So when does their actual clock in and shift start? That's when we say the portal to portal would no longer be applicable. Anything before that could be subject. Once they're under your direction and control, that's when their time should start under the scenario I gave you before where the person was 9. Why can't we get to that?
Paul Trimmer for the Nevada Resort Association. The hypothetical that you're describing is taking out, and it's assuming that the rule called the continuous workday rule doesn't exist. So if once they perform a compensable act, which in your hypothetical is going through a security checkpoint, every minute after that is deemed to be compensable. It's part of their work shift. So even though that's not part of the time that they're scheduled to work, if we treat the going through the security screening as compensable, everything after that is compensable. You wouldn't be able to slice and dice the 10 minutes there in the security line. Then all of the rules, the background rules we have around cleaning uniforms for free and giving employees time to change into them at work, that would be compensable because they went through the security checkpoint. And then same thing with going to the gym. In the status quo, when they're allowed to come into the back of the house without starting the clock, they use the gym, they drink free coffee, they enjoy food for free. You wouldn't be able to do that if once you go into the building, the clock starts because of the continuous workday rule.
That's not what I'm saying. I'm not saying the clock would start as soon as they went into the building. I would say the clock would start when they start their shift. If you require them to do something before the start of their shift, like the COVID test, that would be compensable. All of the other stuff you just said, that's voluntary, they can come in and use, and the clock hasn't started. And you're saying, no, the continuous shift rule starts as soon as they badge into the free area. And I don't think that's correct.
Paul Trimmer for the Nevada Resort Association. Under Malloy, that would be the rule.
Understood, and we're trying to correct Malloy. Now, how we correct Malloy and where we go, or we make everything favorable to the employer on the status quo, or do we say, hey, can we correct some other injustice that that poor guy out at Amazon was doing and workers that don't work in your facility to get past this, what'd you say, start a shift, right? Continuous work shift. I don't know where that rule is. It's not referenced here. It wasn't referenced in Malloy that I saw, and I read it a couple of times. So I don't know where that rule or law comes from. Is it federal? Is it state? You know?
It's federal. It's out of the FLSA, but it's also and I'm sorry, Paul Trimmer for the Nevada Resort Association. It's also adopted in, I can't cite to them right now, but in the labor commissioner's opinions about how daily overtime functions and the 24-hour rule. That's how once you begin performing work, that's when your 8 hours would start. And in this case, because Malloy concluded that going through a security checkpoint began the workday, all of all of those checkpoints are established at the perimeter of the hotel.
And
The hypothetical that you're describing about starting work would essentially require a large hotel will have up to over 100 clocks. I don't want to name names, but many hotels have 100, 150 time clocks. So that way they have time clocks that are convenient and close to employees' workstations. Under the hypothetical you're describing, if under the continuous workday rule, we would have to have 150 security checkpoints that are already inside the building. And this amendment is intended to ensure that the status quo remains the status quo, and then give the legislature time to deliberate and make decisions about what other additional heightened protections Nevada should provide, rather than wipe the slate clean the way that this decision did.
And you keep saying, well, under Malloy, these are the rules. Well, we're here to change that, right? So I don't care what Malloy says. Take it off the table. We're going to make new standards, new rules, new understandings, new stable regulatory scheme, right? That makes sure that workers, not only at your establishment, but others, when does that compensable time act start? And I'm telling you that it doesn't have to start as soon as they walk on the property or they're taking advantage of these various things. Where it starts now, even all of the stuff that I said, you're saying it doesn't start. Under Malloy it does, but we're going to change Malloy, right? It starts as soon as they check into the deal. That was a compensable act to go through the security to get into this area because you have security checkpoints for all of your people. Mm-hmm. I'm saying that doesn't have to be, if we want to change it and write the law the way we need to, that their time isn't going to start till they're going to then, a second act after they've come through, a second act to actually clock in and go to work. If they have to go through additional security at that particular point, the screening or whatever, that would all be compensable. And then until they get to the end of their shift, when they come back out, that's the end of their time. And if they want to take advantage of the meal, this, that, the other thing, and we could write it. I don't care what Malloy says now. Mm-hmm. And I understand the problem that Malloy has created. I'm just saying how we fix that, we can take care of the same issues and the issues of the preliminary, post-preliminary, required to be there or you're fired time, that under the portal to portal without some more language would be non-compensable. As you said, they've made those decisions. But we can make it compensable. We just matter where we start it. And we want to be fair and start it when the people are required to be there at the direction control of the employer, under their control. And we can do that, can't we? It's possible to do. That's all you need to say.
Paul Trimmer for the Nevada Resort Association. Yes, it's possible to do that. And we believe the amendment establishes a clear baseline that would allow the legislature to make other decisions about any other heightened protections that need to be imposed.
Well, you understand, I think, where I'm going and what we hope we can get to. And I just need to have the words allow for that, because I don't think a person should have to be under the direction control of an employer for 9 hours, but only doing his specific job he was hired to do, and this ancillary work is unpaid when he was at the direction and control. He can't leave. You can't get fired, right? People that I used to represent in the construction industry, we would tell them, I says, your time starts when and where you're told to report for work. So you get there and the employer's not ready to go and you're standing around, that's the whole engage to wait thing. I understand that. I says, if they want to have you do calisthenics and pre-warm-ups and go through a job safety meeting or whatever, it's all paid time. And you're on the clock. If they send you from one job to the next and they're driving and all that stuff's covered by the labor commissioner and all of these rules and laws until you're off shift at the end of the day. That's when your time stops. Whenever you're under the direction and control of the employer. And then we have collective bargaining agreements, potentially. We have custom and practice where we could file grievances, which is covered in the federal arcane language, if you ask me. It's kind of old. But not every employee in the state has that, and I'm trying to watch out and have consistent regulatory scheme for all employees in the state.
Thank you, Senator Daley. I have a question, and then I think we have a couple other questions. There's been some reference, and you made reference to it, regarding the Busk v. Integrity Staffing Solutions case of 2018. And there's been some arguments, and we've heard, I know other people in the committee have heard that the Malloy decision, or it wasn't a decision in the advanced opinion, kind of just confirmed what was already existing in that 2018 decision. Can you kind of explain your opinion on that and how you think those two, I guess, opinions from that Sixth Circuit? And just to be clear, I know that that Sixth Circuit was a multi-jurisdictional, prevailing case for us in Nevada, even though we're in the Ninth Circuit. So if you can kind of explain that and why you think that this hasn't been the case since 2018, and that this Malloy decision in October of this year changes that.
Paul Trimmer for the Nevada Resort Association. The Malloy decision adopts a new approach to interpreting Nevada law. So I guess let me back up and answer the first part of your question first. So those cases against Amazon, including Busk, started out in the Ninth Circuit and going to the U.S. Supreme Court. And in that Supreme Court decision, the court decided or concluded that the Portal to Portal Act doesn't cover security and other types of screenings. And then, as you've already mentioned, there were state law claims that went to an MDL in the Sixth Circuit. And the Sixth Circuit, several years ago, concluded that if it was forced to guess about what the Nevada Supreme Court would do, it would likely conclude that the Nevada Legislature had not adopted the Portal to Portal Act. But to your point, the Sixth Circuit is not the Nevada Supreme Court. It was not until Malloy that this issue was actually posed to the Nevada Supreme Court by a U.S. District Court judge in Las Vegas. And the decision that was issued in Malloy was a surprise to large employers in Las Vegas. As I mentioned earlier, there are a number of places where Chapter 608 specifically provides otherwise. So 608.018 has daily overtime. There is no daily overtime under federal law. 608.018 has a collective bargaining exemption that it pertains only to overtime. There's no such thing under federal law other than as a provision that deals with doffing and donning certain types of clothes. 608.160 deals with tips. As many people know, this has been around for a long time. Federal law permits tip credits that allow for employers to pay employees just over $2 an hour plus tips. Nevada law has never allowed that. So large employers have always understood that when Nevada law says otherwise, we follow Nevada law. But in the absence of an expression from the legislature, the background rule has been the FLSA and the Portal to Portal Act. And that was confirmed by a number of Supreme Court decisions that said, and they're cited in the Malloy decision, that state law generally mirrors federal law. So it's fair to say that a federal court in I think it was in Pennsylvania, no, it wasn't Pennsylvania, in the Sixth Circuit decided that this is what the Nevada Supreme Court might do, but that was not what the Nevada Supreme Court actually did until Malloy.
Thank you for that distinction. I think Senator Neal has some questions as well.
Thank you, Madam Chair. I just have one question. So when I was reading section 1, and this is more of just a confirmation, it's under the 29 USC 201. I'm just trying to make sure that if a court was to then read this new statute upon passage, right, then the economic reality test under 29 CFR 795, which nuances two parts, right? It talks about, I don't want to get into what, but it has like direct control of the employee and what's, there's these two parts that really kind of speak to this conversation. A court would still see this language and say, I am going to apply the economic reality test to compensatory time, and then look at that, those subsections under 795110, that CFR, to say, hey, this is direct, this was control, this was what we have already established are factors to review. With that, that's really the question. That's what I want to know. Would the court still be able to apply that test under how this language is written?
Yes.
Okay.
The Nevada Supreme Court used that same test in Terry versus Sapphire Club. And then this, by referencing those provisions in the statute, we would be preserving the status quo and making it clear that, yes, like looking to the FLSA in that context was appropriate, and continuing to do so would be appropriate.
Thank you. That was my question.
Do we have any? Just one. Go ahead, Senator Daley.
I've made my point on all the other part of it. Just one question, and it would be in the section 3, in companion with section 3, and it was. Let me get to it. There we go. So on the part, and I don't have a problem with that language per se, but when I go back and I read sections 3 and 4, and I got like 254 and 253 of the Portal to Portal Act, in 1947, old language, like I said before, where it says employer is not liable for anything that he didn't know he might have done prior to this date. And then there are two exceptions, or a couple of exceptions, is that if you were an employer that already had an express agreement or collective bargaining agreement, you have to continue. If you were paying these things that are now excluded, you have to continue. And then it said the same thing on a customer practice. If that was in place, you would have to continue with that. I read that correctly, that those are exceptions to what the Portal to Portal Act applied to everybody else and the limiting of the liabilities.
Well, Section 9 of the Portal to Portal Act contains a provision that allows employers to rely on opinions issued by the Department of Labor. Section 10, and those are not included here because that's not what the status quo is. Section 10 of the Portal to Portal Act allows for employers to rely upon a good faith belief that they were complying with the law when they're fighting against a claim for liquidated damages under the FLSA. That's not part of this amendment. So this has been, sections 2 and 4 are about compensable time and non-compensable time, and what we believe to be the status quo. And this isn't trying to change any of that. So
I'm specifically in reference in changing the new date and then looking at the existing law, because when you read 252 and 254 as similar language, under A, liability of the employer, no employer shall be subject to liability under the Fair Labor Standards Act or the Taft-Hartley Act, or Davis-Bacon, excuse me. And then it goes on to say under A1, except provisions of written non-contract, written or non-written contract in effect at the time of such activity. So when they put this in place, they're saying, hey, we're going to exclude this preliminary and post-preliminary employment, But if you were already and had a provision, written or non-written, that you were following, you have to continue to have that as compensable time, the way I read this, and that's what I'm asking.
Right.
And then the same thing with 2A, or 2A2 was a customer practice in effect by that employer. So they weren't trying to hurt anybody. They weren't trying to take anything away from anybody when they passed this. And they said, this preliminary, post-preliminary, riding to work, walking, all this stuff is non-compensable under the Portal to Portal Act. But if you already were doing some of these things, you have to continue, the way I read it.
Well, Paul Trimmer for the Nevada Resort Association. If for example, an employer has a collective bargaining agreement with a union that requires that employer to compensate for travel time or compensate for any of those other things, this amendment would not invalidate the collective bargaining agreement.
No, and I understand, I didn't think it was, and I'm just trying to make sure I'm understanding it correctly. And then a customer practice. So like I gave in the example for the union I used to represent, we told them, you were, start your time when and where they told you to report for work, right?
Mm-hmm.
It may not be expressly in the collective bargaining agreement, but it's a custom and practice that's been, we have a grievance procedure, we can go forward and get that person paid. What I'm really talking about when I get to Section 3 is if we're updating the, hey, there's no liability part of it, and I know it goes clear back to 1947, would we potentially be able to update and say, hey, any terms of an agreement, written or non-written, various things, in other words, update those to the new date and say, hey, prior to October 30th, if you were doing this stuff, you have to keep doing it. So you're eliminating the liability, but the same as they made exceptions, if you were already doing something, you have to continue, if that makes sense.
I think I understand your question. I would have to think about that a little bit more. And the reason and I know that's not a great answer, but what you're describing, at least when it pertains to the Resort Association, almost all of which have collective bargaining relationships with the Culinary Union and other unions. If there was a state law mandating what terms and conditions of employment had to prevail, that would likely be preempted by the LMRA, because it would be it would be preventing employers and unions from bargaining over certain terms and conditions. So I'm uncomfortable answering that hypothetical without a little bit more detail.
Yeah, and I'm just looking for status quo there or whatever, right? So in theory, if you adopt the Portal to Portal Act, you guys could claim we're exempt from liability based on this 1947 language, theoretically. We could also claim that we have this, or people could claim we have this protection for an agreement, and that from the 1947 language.
Right.
I'm just saying if we're updating the liability protection, which needs to be done, I believe, should we more modernize or at least bring in and recognize that these exceptions come along with it as well?
Paul Trimmer for the Nevada Resort
And
Association.
just thinking about it, I understand.
Yeah,
I think
it's hard to answer that question in the abstract, but there's nothing wrong with modernizing the law. The purpose of the amendment is not to invalidate any protections. It's to correct what we believe is an incorrect decision from the state Supreme Court about the legislature's intent, and which doesn't match up with how businesses in Nevada actually operate. And it's just to restore and ensure the continued preservation of what we believe to be the status quo.
Yeah. And we have an opportunity to make corrections in all areas.
Yeah.
Thank you. Do I see any other questions? I don't see any for you all. Before she left, Chair Dondero Loop had indicated that she had, because of the complex nature of this subject, this bill before us today, and because it was just recently that opinion came from the Nevada Supreme Court, she had indicated that there would be an opportunity for opposition to present, make a presentation as well. So if I can ask you all to step back temporarily. Thank you for your presentation and your willingness to get into the weeds with some of our questions here. And if I can ask some of the members from the Nevada Justice Association to come up. And for those of you that are testifying for the first time, I'll just remind you, please state your name every time you start to talk if there's a break. Go ahead and begin when you're ready.
Good afternoon, Madam Chair. Joshua Buck from Thierman Buck Law.
Good afternoon, Madam Chair. Leah Jones, also from Thurman Buck Law.
I'd like to thank the committee first for allowing us to come here and speak to you and provide our opposition to Senate Bill 8. I also want to thank the Nevada Justice Association for the work that they've done on this as well on behalf of Nevada workers. As I stated, my name is Joshua Buck. I'm an attorney at Thurman Buck here representing in my own capacity to hopefully address some concerns and questions from the committee. A brief background, I am an attorney who had and litigated the integrity staffing bus case from Nevada all the way up to the United States Supreme Court and all the way to the Sixth Circuit Court of Appeals decision back in 2018. I'm also the attorney who had litigated the Malloy case as well. So when we talk about, I want to talk about the current status. The status quo has been talked about a lot in preparation for this and in presentation. The status quo as we sit here today is that when an employer requires an employee to do something, to do some work, they need to be paid for it. The proposed language of this bill to add the Portal to Portal Act would be a dramatic reduction in worker rights in the state of Nevada. It would provide that employers could require employees to perform certain preliminary and post-preliminary activities and not receive compensation for that. I think it's important to note this is not mere hyperbole. We've witnessed this, and this is clear in the cases that I have litigated for the past 10 years. If you look at Integrity Staffing v. Busk, that was a case that I represented an employee who worked in an Amazon warehouse who was forced to go through an anti-theft security screening on the way out of the facility. And this was back in 2010 when there were thousands of employees at these Amazon warehouses. The Amazon warehouse is an anti-theft screening similar to an airport screening where we had testimony where it would take 15 to 20 minutes every day to leave the facility. It was mandatory, required by the employer. Employees could not choose to avoid the security screening, but yet they were not compensated for that time. We filed a case under both federal law and Nevada state law and other various states as well, such as Arizona. And as I think was alluded to, that case did go all the way up to the U.S. Supreme Court. The U.S. Supreme Court held that under the Portal to Portal Act, even though an activity is required by an employer, the employer need not compensate the employee for that time. That is the state of the law. Integrity Staffing v. Busk is the most recent seminal case to interpret the Portal to Portal Act. That is exactly the type of solution that this bill is proposing, is that employees who perform certain preliminary and post-preliminary activities will not receive compensation. Nevada law is different. It has been different. It has never adopted the Portal to Portal Act. The recent Supreme Court case from Nevada recognized that, but that wasn't the first appellate court case to squarely address the issue. The first appellate court case to have squarely addressed the issue derived from the exact same Integrity Staffing v. Busk case that I talked to you that went to the U.S. Supreme Court, because the U.S. Supreme Court only resolved federal law. The Nevada state law claims remained and had to be litigated. Those claims subsequently went to the Sixth Circuit. The Sixth Circuit Court of Appeals addressed squarely the question of whether Nevada and the Nevada Legislature had ever adopted the Portal to Portal Act. It went through the great analysis. I recommend everyone read that opinion. It talks about how to determine whether something is work. The requirement of work is whether an activity is required by the employer, not voluntary. When it's required by the employer and done for the employer's benefit. The decision then goes and looks at whether or not Nevada had excluded from compensation certain work activities. And in the analysis, it concluded it had not. That was in 2018. So the Malloy decision, yes, it is an important decision in the fact that it is the Nevada Supreme Court making a decision affirming that Nevada has not adopted the Portal to Portal Act. But to say that the status quo changed radically 3 weeks ago, I think is not entirely accurate. At least as far as 2018, there was a precise issue presented before an appellate federal court that had been decided that no, Nevada does not adopt the Portal to Portal Act. Fast forward shortly after the integrity staffing bus case in 2018, Amazon at that point in time was required to pay employees for the activities that they require these employees to do on their premises, whether they be after their shift or not. The Malloy case, as Senator Daley indicated, involved a slightly different activity. It was not an anti-theft security screening being mandated at the end of the work shift, but instead this was a pre-shift COVID screening that was mandated at the beginning of the shift. And again, Amazon made the decision to not compensate these employees for that activity that was both required by Amazon and done for Amazon's benefit. That ultimately went to the federal court, which was the federal court certified it to the Nevada Supreme Court. The Nevada Supreme Court's decision in Malloy, I would dispute that it is a radical departure from the status quo and something that has never been done before. The Nevada Supreme Court employed well-recognized statutory construction and determined that the Nevada Legislature had never, ever adopted the Portal to Portal Act. Simply because other businesses believed that it had should not be a basis for concluding that we should adopt the Portal to Portal Act. I believe that the most, in the proposed bill, Section 1 is essentially where our opposition comes from. And specifically in Section 1 is the addition to the reference, the first clause of excluding from hours of work such time excluded by Section 2 and 4 of the Portal to Portal Act as amended, 29 U.S.C. Section 252 and 254. That section allows for employers to require employees to perform work activities that may not be directly related to the job for which they were hired, to perform those activities before and after their shift without compensation. I've given you a couple of examples that are from my cases, from cases that are published decisions that you all can read. There are other instances from other clients that I have represented who have had other instances of activities that they performed that would similarly now, under the Portal to Portal Act, not be deemed compensable. Such as if an employer would require an employee to perform, to open up a store in the morning and unlock the store, turn on the lights, and boot up all the computers as a bank teller. The Portal to Portal Act will call into question of whether that activity is compensable. Another example would be, and this was an example that was actually posed by Justice Kagan in the United States Supreme Court. Suppose I prefer to have fresh coffee and fresh fruit cut every morning when I get to my office, and I require my paralegal to do that. My paralegal is employed to talk to my clients. My paralegal is not employed to make me coffee and cut fresh fruit for me. I can, under the Portal to Portal Act, not pay her for that time. So to suggest that this proposal is simply the status quo, I think we take issue with. I think this is a radical departure. And I think this is a radical departure from what Nevada workers believe that they should be paid for the time that they were required to perform activities at their job. Thank you, I appreciate it. And if any, I'll leave it to Ms. Jones if she has anything to add, if that's okay, Madam Chair, briefly, and then open it up for questions.
Leah Jones for the record. I don't have anything to add at this time, but we're happy to provide you with some other examples. Thank you.
Okay, thank you. I had to get my directions from my vice chair. I appreciate that. Thank you very much, Senator Wynn, and thank you for your indulgence while I ran and presented a bill. Are there any questions from the committee? Senator Neal, please.
Thank you, Madam Chair. So I guess my question is, how is it a radical departure if the assumption was until this case that folks were operating or believed that the Portal to Portal Act applied, right? I guess that's what I'm confused about. So is it really a radical departure if everyone's assumption before the Malloy case was X and not Y that you presented today?
Joshua Buck. Well, I believe it is, as I stated, I think the first case to have addressed it was in 2018. They said that Nevada law does not follow the Portal to Portal Act. I mean, so if you're going to, I mean, they squarely addressed the issue. So to consider that that at that point in time, that would have been the highest court to have addressed the issue. That they said that Nevada does not adopt the Portal to Portal Act. For the last 7 years, that has been on the books. It's been citable. Every law firm who practices in this area has known that to be the case. But I think that the reality is that we're accepting statements from industry to say that this is what they believed it to be. To be honest, Senator Neal, obviously we felt differently, which is why we have had cases that believe that employees should have been paid for that time, and that's what the Amazon decision was a result of.
Can I follow up? So if there was a case in 2018 that pretty much decided that the Portal to Portal Act was not applied to, so then why wasn't there some kind of, I guess, statutory change before now, or was there and I just don't know about it?
Great question. Joshua Buck. I don't know why there wasn't. I don't know why that if there everybody knew about that decision. I don't know why it wasn't proposed at a general session in 2018 or 2020 or 2022 or 2024.
Can I have another follow-up? Yes, please. So could it be argued that the industry practice then became custom, like a custom of the industry? I mean, if a case came down and the law didn't change, the legislature didn't take it up, can't the argument be made that now the practices that were adopted are the ones that really should be codified?
Joshua Buck, Madam Chair. Yes. Because in 2018, the appellate court said Nevada does not adopt the Portal to Portal Act. In 2018, the Amazon workers were compensated for having to go through their anti-theft security screenings. I know from personal experience from that case, Amazon changed its practice to make their security screenings so that there was no obstruction to leave the facility. And that there was they essentially abandoned their airport-like security screening system so that employees could simply walk out of the facility so that the issue was resolved.
So, Madam Chair, I mean, I don't know if I'm like asking a strange question, but if industry or several industries have been behaving a certain way for the past 7 years, and they want those practices to remain, what's the argument against it again? I know what you just said, but it seems like in the presentation, folks were operating under a set of beliefs and they created practices, although you're saying that, the Portal to Portal Act never applied, but clearly there were practices and customs that they are trying to keep intact, or that is how I'm understanding it. And what is wrong with trying to keep those practices intact for certainty as a business?
Yeah, I'm not sure I'm
Because maybe
Joshua
I'm
Buck?
missing the point.
Yeah, so the Portal to Portal Act exempts, says it as an employer, you don't have to pay an employee for performing certain activities. Okay? That's what the Portal to Portal Act says. In 2018, the Sixth Circuit said Nevada has not adopted the Portal to Portal Act. What that means is Nevada requires the employers to pay employees for all the activities that they require these employees to perform. That was on the books as of 2018. Why industry didn't come to the Nevada Legislature in 2018 or shortly thereafter to attempt to make a legislative change at that point, I can't answer that.
Well, can I ask you this? I mean, clearly we're having a conversation. There's two sides to the coin, right? So there's more than one entity that can come to the table, right, and ask for changes to the legislature. So, why didn't the NJA do it in 2018 or 2020 or any of the sessions before now?
Joshua Buck, Madam Chair. Senator Neer, because I can't speak for NJA, I can speak for myself and for representing workers, because we prevailed, Senator. We prevailed in 2018. We prevailed with the argument that the Nevada Legislature has never adopted the Portal to Portal Act. And if you look at Chapter 608, there has never, ever been any adoption of the Portal to Portal Act. What the other side is saying is the status quo is simply a status quo in their mind. They've always believed that this was the case, but there's no statutory text to support that. And that is what the Nevada Supreme Court ruled in Malloy. If you look at the Malloy decision, the Nevada Supreme Court says, under NRS 608.016, it specifically states that employees shall be paid for all the hours that they work, with two not relevant exceptions. The Nevada Supreme Court says, had the Nevada Legislature wanted to provide additional exceptions, such as those found in the Portal to Portal Act, they would have done so expressly. So there would be no reason for me, in my own personal capacity, or I suppose NJA, to present legislation to affirmatively state that we do not adopt the Portal to Portal Act.
Chair, if I may. Misha Ray here on behalf of the Nevada Justice Association, through you, Chair, to the Senator. Senator Neal, I believe the shorter answer to expound on what Josh Buck said, we believe the current state of the law, the version of the law that the Nevada Supreme Court recently affirmed via the Sixth Circuit Court opinion as well, is more worker-friendly. We have, as this side, have always believed the Nevada Supreme Court's version of this case to be the case, that it's been more worker-friendly in this way, that the proposed change here is more employer-friendly. So we have been operating under this set of assumptions that Nevada Supreme Court's version of the case is correct, and you've heard from the other side that that was not their understanding. So NJA has been under the impression that the Nevada labor laws have been more on the worker-friendly side. So that's our perspective, and I hope that addresses your question.
Okay, thank you. If you'll hang on just a minute, Senator Wynn, I'll go to Senator Daley, please.
And thank you, Madam Chair. So along that same line of questioning, maybe just a little different angle, if you will. So does the belief and presumption of employers, all employers, I don't care who it is, Does their belief that the Portal to Portal Act always existed applied in Nevada, which now we have 2 court cases that says it didn't, and you said clear back to 2018, does their belief and presumption make it a fact that their belief and presumption was correct? Is it a fact or just a belief?
Joshua Buck, Madam Chair. Senator, it's just a belief. I mean, there's 2 court cases that have said the opposite.
So in fact, their belief was incorrect, and then their reliance on that, or their belief, and then their continuing practice, even though unchallenged for the most part in that, does that mean that they're not, or were not, or are not responsible for potentially that compensatable time that they weren't paying because they believed they didn't have to? Or is their belief just a belief and they were actually supposed to if the circumstances warranted?
Joshua Buck, Senator. It's just their belief, and they're responsible to comply with the law.
Yeah. And that's kind of where we're getting to, is that now that it's a Nevada case and it's at the top of everybody's issue, we do need to address it. I believe we need to fix it. I have no problem with that, saying, hey, if there was an error made, a belief, presumption, and that was the custom, the practice, whatever it might have been, although inappropriate or maybe not correct under the law, that we're going to say, hey, you acted in good faith, so we're not going to, let people sue you over that. I disagree with that. I think that's reasonable and fair under their beliefs in trying to act in good faith. It's a matter of, I think, the problem when we have the disconnect is how do we fix that to make it fair, not just to one industry with great practices, good bargaining relationship with their employees and that union. That's one segment of what we do. It doesn't cover everything or all employers, and there's a way to do it, as we said before. I'm just saying that just because that was their practice doesn't make it right, and that's what we're here to fix. And I agree we need to fix that part, but we need to fix the other part too.
Thank you very much, and I'll go to Senator Wynn.
And I don't know if Mr. Trimmer is still available. Oh, man. Well, maybe Ms. Valentine, I don't know if anyone might be able to answer this question. I'll just put it out there. Maybe someone will pop up and have the answer for it. But I'm looking at just an article kind of summarizing some of the cases that we've talked about from the law firm of Jackson Lewis. And they had indicated, they make reference to this 2014 U.S. Supreme Court case that said that the Federal Fair Labor Standards Act, as amended by the Portal to Portal Act, did not require employees to pay for employees for such time for the security screenings. And obviously that just addressed the federal claim, and so it was very clear in that case that the Portal to Portal doesn't provide as many protections as we do under Nevada law. So I'm curious to see, because there was an indication by Mr. Trimmer that we were staying at the status quo. So how does adopting the Portal to Portal Act here in Nevada maintain those protections if the Supreme Court was very clear that they're not included? I don't know if someone from the proponents might be able to answer it. I know that's
Virginia
very
Valentine, thank you for the
technical.
question.
And I saw him leaving, and I was hoping he wasn't leaving, but
I think I can text him Virginia Valentine, I think I can text him the question if you can say it, and as the hearing continues, and I will try to get you an answer to that.
okay. I think I'm just curious if the Supreme Court has been very clear that the Portal to Portal Act is, I guess, protects employees less than what we do in Nevada. If adopting that Portal to Portal language would leave our employees with less protections.
Virginia Valentine, thank you. We'll see if we can ask him that question and get you an answer.
Thank you. And I don't know, you might be able to answer that too, Mr. Buck.
Joshua Buck, Madam Chair, may I respond? That is the bus case, the 2014 case that you're referring to. If you adopt the Portal to Portal Act, you adopt that case.
All right, any additional, Senator Rogich, please.
Thank you, Madam Chair. I just wanted to tease out further examples of the benefit to the employer. So we heard about some of the privileges that the employees receive at a large resort, say working out at the gym. And so wouldn't it be to the benefit of the employer for the employee to be in a healthy condition? So would we be walking down or sliding down that slippery slope?
Joshua Buck, Madam Chair, may I respond? Great question. I think there's two different tests that you look at. One is whether the activity is required. So let me respond to that hypothetical, assuming it's not, if it's just a voluntary thing. Hey, we would like to have employees who are healthy, they don't miss work as much. It is to our benefit, but it's not required. It's not compensable. Second, I guess I'll expand on that if you allow me. Let's just say the employer actually says, we require you to go work out at the gym because we require our employees to be of a certain fitness level. Then it would be compensable. Because again, we're talking about employers requiring employees to do activities. Every time that we start talking about the requirement, employees have less time to spend with their family, their friends, to do other things that they may want to do. Maybe they have another job. But that is that is at its core, that is the issue that we're talking about. That was the issue that we were talking about in Amazon with the security screenings, is that they are required by the employer for the employer's benefit of inventory control. And like I said, under federal law, it does not matter if an activity is required or done for the employer's benefit. That's not the end of the test. They can still, it is not compensable. And under Nevada, I believe that we have stronger worker protections than that.
Yes, sir. Senator Steinbeck, please.
Thank you. So the example that was given before in the earlier testimony was that if somebody was to go through a security checkpoint, right, check in just through the doors, then everything past that point, whether they did something voluntary or something required, but that they would have to pay that entire time, whether they went to the gym, whether they went to eat, whether they did anything along those lines that maybe wasn't required. The example given before was that they would have to pay all of that. But you seem to be in dispute of that. Is that correct?
Joshua Buck, Madam Chair, may I respond? I am, based upon that hypothetical, there's not, that would be what we would consider to be a de minimis activity, is simply swiping a badge to get into a particular location, and so that would not initiate the continuous workday doctrine. That would not initiate the response that they'd be required to pay for that time. So the example of, and I've been to some of the casinos from other cases, if an employee goes through the employee entrance, a lot of casinos have the employees show their badge to the security officer on duty and then walk through a metal detector. But there's no actual there's no actual task being performed other than raising their badge or showing their badge. That's why the de minimis doctrine exists. And so no, it is not my belief that employees would be compensated for that.
May I ask a follow-up, please? So how about in the other example, or the Amazon example, if you went through a health screening but then did voluntary activities after that?
Joshua Buck, Madam Chair. So if the health screening was required by Amazon, and let's just assume for the fact at the end of the shift, required by Amazon to be performed, or I'm sorry, maybe I should clarify, the beginning of the shift?
Yes, beginning, please.
Yeah. That would be compensable time because that is the beginning of when the employee, if it's something that is not a de minimis activity, and I think the hypothetical, particularly in the Malloy case, was something around 20 to 30 minutes of time for the waiting in line to take the test, taking the test, waiting for the test results. that is a work activity that would begin the workday. And like I said before, that's not a de minimis activity under the law.
All right, additional questions from the committee? All right, I think that's it right this minute. Thank you for being here, and we will let you off the hook for just a minute. Don't go far. And we will go to those in support of Senate Bill 8. So if you are in support of Senate Bill 8 and you would like to make some comments here in Carson City, please come to the table now. And please go ahead when you are ready. Thank you.
Thank you, Madam Chair, members of the committee. My name is Tom Clark. I'm here on behalf of the Reno Sparks Chamber of Commerce and also on behalf of Kinross Gold. Very much in support of the legislation that was brought before you. There was a lot of legal jargon and a lot of legal conversation around this particular piece of legislation, but we do know that if passed, it will be a benefit to Nevada workers and to Nevada's employees. Specifically to what was mentioned during the presenting testimony, and that the amendment that will be coming forward that will also have this legislation affect those pending cases that are currently being heard. Thank you, Madam Chair.
Good evening, Madam Chair, members of the committee. For the record, I'm Paul Enos. I'm the CEO of the Nevada Trucking Association, and we're here today to support Senate Bill 8. We do believe that this legislation gives us some clarity that we need after the Supreme Court decision. That there has been a status quo, and a lot, we talk about the beginning of the shift. For my guys, sometimes at the end of the shift. There are times where a company will let a driver take a truck home because, he has an early route or, different place to go. So, that maybe 2-3 minutes, doing that security check, taking that truck home, is that now compensable? So, we do feel that there is a tremendous amount of uncertainty because we are changing a practice that has been occurring for, 80 plus years in this state. So it either needs to be legislated or litigated. We think legislated is the much better route. And so we do appreciate this body's consideration of this measure and hope you move forward to give businesses some certainty in terms of what we need to do to make sure that our employees are, yes, we want them compensated for the time that they are working, but to answer that question where there may be a little bit of nuance. So thank you.
Good evening, Madam Chair, members of the committee. Carrie Kramer here on behalf of NAOP. I'll keep it short and sweet. We are here in support of SB 8 and its amendment forthcoming for all of the reasons that were previously stated. Thank you.
Good afternoon, Senate Committee on Jobs and Economy. My name is Cassidy Wilson, CASSIDY, I'm here on behalf of the Builders Association of Northern Nevada. We are in support of SB 8, and I want to echo my colleagues' comments. Thank you so much for your time and consideration.
Good evening, Madam Chair. For the record, Trey Abney, TRAY-ABNEY, here today representing NFIB, National Federation of Independent Business. I'm obviously not required to work out for my job. I want to echo the comments of my colleagues here, and just to point out, we've talked a lot about resorts and big businesses, and it's certainly important for my friends in the resort industry. But this court case affects every employer in Nevada, including the very smallest. And so I wanted to make sure to have that on the record. Thank you, Madam Chair.
Thank you very much. Yes, we're required to sit, and we do a really good job. Please go ahead.
Thank you, Madam Chair, members of the committee. Jay Parmer, Jayparmer, on behalf of the Nevada Manufacturers Association. We're here because the manufacturing sector would like some clarity on the Supreme Court's ruling. We feel that Senate Bill 8 and the forthcoming amendment will provide that clarity for the manufacturing sector. Thank you.
Thank you, Madam Chair. Alexis Motorex with the Nevada Chapter Associated General Contractors. We too are here in support of SB 8 and the forthcoming amendment, and just for all the same reasons that have already been stated. Thank you.
Good afternoon. My name's Patrick Kelly with the Nevada Hospital Association. We too are in support of the bill. Thank you.
Good afternoon, Chair and committee members. For the record, Becky Dutro, D-U-T-R-O, with Nevada Taxpayers Association. The association is in support of this bill and the importance of simply codifying what taxpayers in Nevada have understood the law to be. Thank you for your time and consideration of this bill.
Good afternoon, Madam Chair. Jason Gray, G-R-A-Y, Vice President, Government Affairs, MGM Resorts, here to express our strong support for Senate Bill 8. I do want to thank Governor Lombardo for allowing this to be heard during the special session. The Supreme Court decision that came down on October 30 caught us all by surprise. I want to thank the Majority Leader, of course, and Madam Chair, you and your committee for allowing this bill to be heard, particularly in such accelerated fashion. It means a great deal. We support swift action to address a sudden and expansive Nevada Supreme Court decision in Malloy that unfortunately put all Nevada employers in a very precarious and vulnerable situation. Senate Bill 8 endeavors to reestablish the status quo. I understand we have differing opinions about what the status quo means. We want to preserve our normal operating conditions as they existed before the Supreme Court decision, put simply. And treating employers properly and fairly and protecting them from substantial and material monetary exposure and harmful operational impacts, of course, is our number one priority in asking that this bill get actioned. We all know who benefits from ambiguity and uncertainty in the law on these types of issues, and so we beg that this bill be progressed so that we can establish some certainty and predictability for Nevada employers. I urge your consideration and support for the bill. Thank you.
Good evening, Russell Rowe here on behalf of Boyd Gaming Corporation in support of SB 8 that will return the status quo of clarity and predictability to employers and employees in Nevada. We greatly appreciate the committee for taking the time to consider this critical legislation, and we strongly support your favorable action on this bill. Thank you.
Good afternoon, Madam Chair and members of the committee. Carlos Lasane, that's K-A-R-L-O-S, Lasane, L-A-S-A-N-E, Vice President of Government Relations for Caesars Entertainment, representing Caesars Entertainment. We fully support SB 8, and I thank you for your consideration, and hopefully you will support it. Thank you.
Chair, somebody like...
You know, this is just an oh-so-special session, isn't it? Thank you very much. All right, seeing no more here, let's go to Las Vegas. Is there anyone in support in Las Vegas? I don't see any. AABH on the phone lines, please.
Thank you, Chair. Public lines are open and working, but there are no callers to provide support testimony at this time.
I'm sorry. I do see someone in Vegas, and I was trying to read sign language down here, and I didn't catch it. So please, if you're in Las Vegas, please go ahead.
Thank you, Chair and members of the committee. My name is Eric Cardona, and I'm here representing the Henderson Chamber of Commerce, to whom the majority of our business owners are small businesses, and here in support of SB 8. The Malloy v. Amazon ruling represents a significant departure from what employers reasonably understood the law to be. Its consequences are far-reaching and potentially devastating for Nevada businesses, including small businesses. Because of this, we support this bill, as well as the amendment that would include retroactive dates to cover this coverage and encourage the legislator to consider making the retroactive date consistent with the effective date of the federal statutes Nevada is adopting. Thank you for your time and consideration.
Thank you very much, and I'm sorry, and thank you for those in the room that were trying to signal me. Thank you. All right, with that, I think we've caught everybody who is in support, so we will go to opposition here in Carson City. If you are in opposition of Senate Bill 8, if you would like to come to the table. Seeing none, we will go to Las Vegas. I don't see anybody there. If you do, stand up and wave at me. AVH, is there anyone on the line in opposition?
There are no callers to provide opposition testimony at this time.
Thank you very much. All right, we'll go to neutral here in Carson City.
Thank you, Madam Chair and members of the committee. My name is Nikki Bailey Lundahl. I represent the Nevada Mining Association and our hundreds of member companies across the state. We are neutral in this measure as drafted, but are looking forward to bringing forth an amendment and continue to work on this. Our issue with this is acute and specific to our industry. I've had the privilege of showing most of you Nevada world-class mining industry for years. You have seen our remote operations. You understand the long distances between our sites and the nearest towns. You have seen firsthand the great lengths miners go through to protect their employees and to protect one another. For example, some mines require employees to ride the company shuttle from town to mine site. On this shuttle, employees sleep and rest, call their families, even scroll social media. Under current law and spelled out in NAC 608.130, this is clearly not compensable time. But coming out of the Malloy decision, it is not clear whether that regulation will withstand judicial review if challenged. I am here before you to appeal for that clarity. I do not claim to be a labor lawyer, but I can tell you definitively that since the Malloy ruling, a single Texas-based law firm has targeted our industry with more than 10 class action lawsuits. These lawsuits target the industry over things that do not qualify as compensable work under current law, whether traveling to site or to gearing up to go underground. These suits have one thing in common. They rely on the uncertainty coming out of the Malloy decision to disrupt our industry. I want to repeat, we have members being sued for something that is clearly legal under current law based on uncertainty that this ruling has generated. We believe the current labor law should be enough to protect our operations and our personnel, but post-Malloy, following the law as written and the regs, those laws that protect and those laws, that protection no longer seems like a guarantee. We are not looking for any special treatment or to gain any new ground. We are here to ask for this body's assistance to protect our members from being penalized for following the law and doing the right thing for their personnel and their families. Thank you for your time.
Good evening, Madam Chair. My name is Brian Wachter. I'm the president of the Retail Association of Nevada. We too look forward to moving into support of the bill. We think it's important that all of Nevada's industries have this protection going forward. We are deeply concerned, regardless of how we got here, we're facing an economic cliff. Our members have gone through lots of changes in the supply chain. If we are going to have things applied differently retroactively, we would have made different pricing decisions going forward and been able to incorporate that into our business practices. What we can't go back and charge our customers more in order to make up for something that was unclear that we should have been doing. So we look forward to moving into support. Thank you, ma'am.
Thank you very much. All right, is there anyone else in neutral here in Carson City? Is there anyone in neutral in Las Vegas? I don't see anybody waving hands or jumping up and down. AVH, is there anyone on the phone lines for neutral?
Thank you, Chair. There are no callers to provide neutral testimony at this time.
All right, seeing no one else who has comments, Ms. Valentine, would you like to make some closing remarks?
Thank you, Chair and members of the committee. We want to reiterate again that we are simply asking for the status quo, that we think that this change will codify and that the Nevada Legislature's intent is to uphold the decades of practice, past practice that we have relied upon to provide certain amenities, certain benefits, to do our operational practice, even to right down, I think, to the way employee dining rooms are designed. I would agree with the other speakers who said this affects businesses large and small, and hope you'll consider that. And to Senator Wynn, that we will get back to her with an answer. Thank you.
Thank you very much. All right, with that, I will close the hearing on Senate Bill 8, and I will open up for public comment here in Carson City. Is there any public comment? Las Vegas, is there any public comment? On the phone lines, AVH, any public comment?
There are no callers to provide public comment at this time.
Okay, thank you very much. All right, we are going to stand at recess this evening to the call of the chair. So thank you very much for all of you for being here, and we may reconvene. Thank you.